Good afternoon, Europe, and good afternoon, Asia, and good morning to the US. And welcome to this Horden webinar that we have, in which we will try to give you an impression of the situation on COVID-19 in the Danish jurisdiction. Senior Associate Andreas Schönbeck and I, partner Paul Wilson of Horden, are pleased that so many have signed up to attend this webinar today, and particularly pleased as Denmark is a very small jurisdiction. But it's a big world out there, and a lot of capital interests in Denmark, a lot of contractual interest in Denmark have spurred interest to find out how the situation develops in the Kingdom of Denmark. Today's subjects, which Andreas and I will address for approximately 30 minutes, will comprise just a small intro into the situation, the present situation as it is right now, the prospects of it as we have seen it described from authorities, and then the legal consequence into contractual frameworks, the application of force majeure clauses, I would say, difficulties in the application of force majeure in the present situation. What is force majeure and how does it work? And then finally, a short introduction to you on the support measures introduced in Danish legislation to alleviate some of the harsh financial consequences that the COVID-19 pandemic has caused. But initially, the situation. Well, Denmark is one of all European countries hit by the COVID-19. Ever since the start of March, the Danish situation has been that of a lockdown. There are regulatory measures introduced to sanction the activities which are normal daily living. How we meet, how we work, how we live our lives, how we shop, how we do sports, how we interact. Everything has been locked down. And apart from recommendations of hygienic nature, we're simply prevented from doing a normal day's business. And as a matter of fact, the lockdown has caused a complete standstill in the Danish society. Now, that standstill is a temporary measure in order to follow one strategic plan, which is not to combat the illness or the disease, but to flatten the curve. Flatten the curve means that we're all supposed to get COVID-19 some way or the other, sometime or the other, but we will not be allowed to have it at the same time, because that will cause a crash of the health system, and that will even increase an excessive mortality rate of influenza over and beyond acceptable levels. So flatten the curves means, on the one hand, a complete lockdown of the way Denmark operates and how we operate business and activities, but it will also prolong the period in which those measures will work. So what we're looking into is a period of time in which measures may be lifted, but it will be done gradually and cautiously, and the time perspective is of the essence. Nobody knows how long time this crisis will take before we are back to normal living, if we ever will. But the timing of it, the time perspective is impossible to predict. That obviously causes two, should we say, angles to the contractual problem. One is that the contract is hit by a complete lockdown on the one side, but also that the time frame for a new contract to emerge or a modified contract to emerge is impossible to predict. And this brings me to the force majeure issue. What is force majeure and how does it work? Andreas, could you take us through that?
Yes, of course. Thank you, Paul. First of all, as Paul mentioned, the current pandemic crisis has a general impact on society on a global level, and that inevitably also means that it will impact contracts all over the world. What we will talk about today, and what I will talk about today, is the impact the crisis will have on contracts governed by Danish law. On a daily basis, we receive an abundance of questions from clients and other business partners regarding the contracts they've entered into. Maybe they fear their own contractual performance, or they fear the contractual performance of their counterparty. They have scrutinized their contracts and they are desperately looking for some sort of relief or exemption from liability in case of lack of performance. In this case, the obvious concept to discuss is whether or not the parties can invoke a force majeure exemption. And the force majeure exemption under Danish law is a very difficult concept to handle. When we as lawyers advise clients on legal doctrines or legal concepts under Danish law, it would be absolutely ideal if the concept at hand did what it said on the tin. However, that is definitely not the case when it comes to force majeure. No, unfortunately not. And that's why we're here, and that's why people are reaching out to us for advice or sparring in general. The force majeure doctrine in Danish law is developed through case law, through legal theory, and when you attempt to find force majeure in a codified manner in Danish law, you will have to look for the Danish Sale of Goods Act, namely Article 24. Of course, the Danish Sales of Goods Act is only applicable to sale of goods in Denmark. However, the principle in that article applies generally in Danish law. Of course, with it varies depending on what legal area we're talking about, but that's where to look for if you want to look for the codification of the concept. The concept deals with 3 conditions in order to be applicable. First of all, the performance of the obligation has to be impossible. The other condition is that the force majeure event has had to be unforeseeable. And lastly, the condition is that the force majeure event has to be an exceptional or extraordinary event. If we go through these conditions one by one and we start with the impossibility, well, impossibility, that's a strong word, because when is something impossible, and does it have to be absolutely impossible? On a general level, we can say that impossibility at least have to be an objective impossibility. It's not enough that it's impossible for the party in question, the specific party in question. If you've made a bad deal, if you've structured your supply chain in the wrong way, if you've made some bad decisions or made mistakes, during the period the contract is in force, that may cause some impossibility on your end, but it doesn't mean that impossibility applies generally and objectively. It has to be impossibility in the sector, in the industry, on a general level. The other condition regarding unforeseeability means that when you enter into the contract, it must not be clear to you, and you should not have knowledge about the force majeure events in question. So if we at this stage deal with a contract entered into some weeks ago, it would be difficult to advise a client that a force majeure event applies. If we're dealing with a contract which was entered into several months ago, perhaps even several years ago, it is more obvious that the current crisis, the current pandemic, is what we can describe as unforeseeable, at least at the time the contract was entered into. Lastly, we mentioned that one of the conditions is that the event has to be extraordinary, exceptional, which means that you have to consider the probability of the event. If it's something that happens regularly or from time to time, if it's something you know that will happen eventually at some point, then the condition is not fulfilled. If you combine all these three conditions, it is relatively obvious that the force majeure concept in Danish law is quite narrow, perhaps even more narrow than most people would think. For you foreigners, we can describe the force majeure doctrine in Danish law as comparable to the common law concepts of frustration and impossibility, although it has to be stressed, really stressed, that the concepts are not identical.
But it's wider than the concept of acts of God.
It is.
Acts of God is I mean, very narrow.
Exactly. Exactly. Some would, in theory, some would even claim that that could never happen. but that's correct, Paul. If you consider the customary force majeure clause, it would mention acts of God as one of the force majeure events. So that's a part of the force majeure concept, of course, provided that the specific conditions for a force majeure event are fulfilled altogether. So again, we need to stress that there are certain conditions for invoking force majeure to a contract, and the scope of the force majeure doctrine is very narrow. We also have in the CISG a force majeure clause in Article 79. The CISG, the Convention for International Sale of Goods, the United States Convention, is Danish law. It is adopted by Danish legislation. But we need to bear in mind that only applies to international sale of goods. Yeah. So it's not generally applicable. When we're dealing with contracts, we also need to acknowledge that many contracts contain force majeure provisions, which means that the Danish law doctrine of force majeure becomes less significant. In such case, you would have to consult the actual contract. You will have to carefully scrutinize the relevant clause, and you need to consider whether or not the situation you're dealing with indeed fulfills the criteria for force majeure under the specific contract. Sometimes you would see force majeure contracts that simply refer to force majeure as a concept itself, and in such case you need to consider that concept in light of the applicable law, in this case Danish law. But that's just one example of the interplay between the background law and the contract you're dealing with. In most cases, the force majeure clause in the doctrine will elaborate what constitutes a force majeure event, what's the consequence of the force majeure situation, what are the obligations of the parties, and eventually can the contract be terminated if the force majeure event continues to hinder performance of the obligations under the contract. So that's a general concept of force majeure. That's a general introduction to force majeure under Danish law. If we have to provide advice on specific contracts, we need, of course, to review the specific contract, as you've probably done yourself in your own contracts.
But if we go into the question force majeure event.
Yes.
Is COVID-19 a force majeure event in itself?
Yeah. Well, you can consider that from two angles. You can consider that from the contractual provision angle. In such case, you have to consult the actual contract.
Yes.
and answer based on, and then provide an answer based on that. If we approach it from a different angle, if we consider it through the application of the force majeure doctrine under Danish law, one has to say that the actual pandemic as such is not a force majeure event. It's the consequences of the pandemic.
Yeah.
It's the prohibitions invoked by the Danish government. It's the impossibility of obtaining goods from various places in the world, etc., etc. So you have to consider the consequences, because the actual pandemic as such is not as a force majeure event.
So the question, if you have promised, for instance, to deliver personal protection equipment to Danish hospitals.
Yes.
And you can now only get it because if you pay something like 1,000, 2,000% of the price you envisage that you would have to pay, is that a force majeure event?
Yeah, I like the numbers you're putting on this question, because that's that we
200%.
200%, yeah. Because otherwise we were gravitating towards a gray area, I would say.
Yeah.
There is no doubt that the fact that something becomes more expensive, that it becomes less desirable for you to perform your obligations, because the margins you will gain on the business case will be lowered and perhaps even eliminated. That doesn't constitute force majeure. But that, on the other hand, it doesn't mean either that paying 10,000% of the normal price, 20,000% of the normal price would mean that that's just a risk you have to absorb yourself. At some point, it would be economic force majeure. But I think what's interesting to most people listening to this webinar is that the numbers we're dealing with, the factor of the agreed price you have to consider is significantly higher than what most people would think, and what we would definitely have surpassed the threshold of the price becoming undesirable.
Yeah.
So it means that it would, you can't just assume that it's force majeure because it's been somewhat more expensive.
No, it's that then you would have to have a contractual provision for hardship,
exactly,
or whatever.
Exactly, and those provisions would normally go hand in hand. But if it's not there, it's not there.
That's right.
Yeah.
But if your supplier of personal protection equipment for Danish hospitals is a US producer,
yes,
and the producer calls you and say, well, I would go in the US a slight sanction, like 20 years in prison, if I export that to you, because I'm under harsh and very restrictive export prohibitions, because the US needs PPEs themselves. So will that constitute an invocable force majeure argument towards the Danish hospital which are in need of PPEs?
Yeah. First of all, the claims made by the US supplier would mean that the US supplier would do something illegal to supply the goods, and you're obviously not supposed to do something illegal to supply the goods. Whether or not you can use that claim from your supplier as a force majeure event towards your own customer depends very much on whether or not your hands are tied, or whether you have free hands to choose your own supply chain. If we assume that you have free hands to choose your supply chain, you're not restricted by any obligation to use that specific supplier, then to claim force majeure would probably be unwarranted, and to not be able to deliver would probably be it's very likely that it would be considered a consequence of your bad judgment. You should have thought of different sources, use dual sourcing, or at least have the opportunity to source the products from somewhere else. If, on the other hand, you were contractually obligated to source the PPE from that specific US supplier, then that's a different story, and you would be able to use that as a relief under the contract with the hospital.
So it's not only the Danish measures which regulate activities in Denmark, prohibits congregations, concerts, events, or something like that, that will constitute force majeure in a Danish context. It's also foreign and domestic legal instruments brought into place as a measure in the context of COVID-19 that will be invocable.
True, Paul. In your example, you're dealing with an international contract, and in such contract, you would also have to apply a holistic view and include international aspects of the situation in order to determine whether or not you're in the exemption zone or whether or not you will face liability for not performing the contract.
Now, if we had a situation that I sold 10,000 tickets for a concert on June 15 with a famous Danish band, and all tickets are sold. And on June 15, the regulations which are now in place does not apply. Will I be able to cancel?
Well, of course, it depends on various things. First of all, depends on when were the tickets sold, and second of all, when do you cancel the gig? And if the tickets were sold at a time where the coronavirus were known and where we were in the pandemic period, then there is no excuse for canceling the show. But on the other hand, as we also talked about in the beginning, introducing the conditions for force majeure, if it was not foreseeable that the event would be affected, then it's a different story. Of course, we would probably have to include some more facts about this, but to answer this on a general level, it depends very much on these two concepts.
Oh, sorry, very much. Sorry. This is also prohibited, actually. Okay, yeah, but the time perspective is very interesting.
The time perspective is very interesting.
Because we are all having, for political reasons, I think, we are prolonging in periods of 2 weeks or so all the restrictions. We don't take 8 weeks at once. We take 2 weeks at a step forward. So in actual fact, our time perspective is very short.
True.
In terms of force majeure being invocable, because we know that it is prohibited to do what we contracted to do.
But that also leads me to the point that in your example, if you invoke force majeure at a time where there is a prohibition, there are prohibitions, but at the time of performance of the obligation, the prohibitions are no longer there, then you're taking a risk. And that risk may be prudent from a business perspective,
yes,
or from a relation perspective, but it is inevitably and nevertheless a risk, and it may not be force majeure at that time. It will probably not be force majeure at that time if the prohibitions are no longer there.
That's true. So there's a lot of risk connected to making the choice to take definitive consequences of the present situation, when the present situation is so short-sighted as it is right now. Now, what about the situation that you enter contracts now? What do you need to do?
Well, what you need to do now is to consider whether or not the current situation will be extended, whether or not it is likely to affect the performance of the obligations at the time of performance. And in such case, you need to make the relevant reservations for that in the contract. If you don't do that, you can rest assured that it will definitely not be considered force majeure when you enter into a contract during a pandemic. But other than that, if you want to handle it in the contract, you of course need to handle it specifically and to carefully consider what is it you want to get relief from at the time of performance. Is it the current situation? Is it a different situation? Is it development of the current situation, etc., etc.?
And that's exactly why there's a tendency that no contracts are made.
Yeah.
Because the situation is simply unforeseeable.
Yes.
And the distribution of risk attached to regulating the potential restriction on exchange of services when that time occurs is simply an obstacle to entering contracts whatsoever. So Denmark is at a standstill. And that's why if we go to the third element, the Danish government and to a certain extent also Danish Parliament, even though they are a bit lacking behind the Danish Parliament, but the government is really making a point here. They are entering agreements on very large support packages for Danish business, which are Danish business and enterprises which are hardly hit by the standstill. Now, we have made, and you will find that on our web page, a very short, very brief, very superficial introduction to what measures are actually in place in order to support perhaps your subsidiary company doing business in Denmark. And the support initiatives all depend on one a bit risky causation requirement. It needs to be caused by the COVID-19 pandemic and situation. You are not supposed to exploit these support measures for a business which already before the COVID-19 was a bad one. So there are no investigations into whether you've satisfied that requirement now, but it will be a cleanup operation subsequent to the COVID-19 crisis. But the support initiatives are, as we see them now, compensating businesses for fixed expenses that they have while their turnover and revenues are down and even completely out of place. It is salary compensation for employees whose services in their employment are no longer needed, and for a 3-month period you can send employees home and receive a 75% compensation with a max of 30,000 Danish kroner. Now, for a 3-month period of time, they're not supposed to work. There's a strict prohibition that they work while they're sent home, but they need to be available to you, and you may not terminate their employment. You may not terminate employment of anyone in the business that because of the COVID-19 crisis. The compensation should prevent you from firing people and to add them into the queue of unemployment, which is on a very steep escalation at the moment in Denmark. And it's also a special SMV support package for single single entrepreneurs, freelancers, and independent workers, if their revenues and that's their daily livelihood is reduced due to COVID-19, they can get a support. Also, support measures for larger enterprises are installed in terms of granting loans or creating finance bases for larger corporations with a state guarantee. All of the measures taken and introduced will be transformed into Danish law. There's a delay there, so the pamphlet that we made is somewhat superficial and also dependent on the actual transformation into Danish law. A lot of things may happen at that stage. But Danish support to Danish business is there and is available by application and by presentation of documentation, declarations that eventually may prove a bit problematic if the declarations are not entirely true. So it's there for you if you need it. But we've been through the Danish situation. We are very happy that you listened in, and we will, in the course of the coming days and weeks, contemplate whether to make yet again an international address on as a follow-up on the Danish situation. You are very, very welcome to write to us. You can find our respective email addresses on our webpage if you have any particular questions from this webinar. But should we say thank you very much for listening in, hanging in, and take care. You know it's dangerous out there. Thank you very much.